If you read Federalist 78, for example, Hamilton wrote in so many words that the legislature is just that place where cabals and conspiracies by factions occur against individual liberty. And it was thought that the way we check that sort of political problem is by having a judiciary that's independent, a judiciary that doesn't stand for election, a judiciary that doesn't have term limits, one whose salary can't be cut, and one that gets to have judicial review. The judicial power is referenced in Article 3, and everybody knew what that meant at the time. And so I do not believe that there is any special role for the courts to play in deferring to the will of the democratic process. What the courts should do, and whether it's guns or other rights, so long as there's a right that exists, once the right exists, that's the end of the game. The court's job is to enforce that right and apply it, actually engage in the Constitution, and there's really no need to pay much attention to the political branches after that's occurred. I think my time is up. I will sit down.
Thank you, Alan. William Treanor.
Well, I have to say it's it's a rare privilege for deans because we don't usually get to think about stuff. So I was delighted to get this invitation from Federalist Society and from ACS and the Fordham Republicans. And it's a real pleasure to be here today with somebody who's done so much to shape the law, and with Professor Johnson, who really has done so much to put this issue on the table. When I was in law school, it was just clear, really beyond peradventure, that the Second Amendment was limited in scope, that it was about the right to be part of a militia and have guns as part of a militia, and really any kind of alternate argument was really just treated as silly. You know, in the 20+ years since then, there's been a substantial body of scholarship, you know, and bracketing the issue of the way in which the case law has moved. Substantial body of scholarship that has really put the issue on the table and really, you know, made the argument for an individual right that goes beyond something that is part of being a militia. It's put that on the table and made the case for it. What I want to do here, so I want to acknowledge the importance of that argument and its effectiveness. What I'm going to do is, in my time, I'm going to talk about Heller and why Heller was wrongly decided. You know, the Stevens dissent, which is that the Second Amendment is adopted to protect the right of the people of each of the several states to maintain a well-regulated militia, is right. And the majority's view that it's about a broader individual right to firearms is not right. And I do that from the perspective of originalism, which is kind of my take on the Constitution. I'm usually thought to be a liberal originalist, which puts me in a category that's basically me and Professor Flaherty. Has now really kind of mobilized the nation. But you know, it's based on the idea that you know, originalism is the best touchstone of constitutional interpretation because it is the most consistent with the majoritarian decision-making of we the people. We the people adopted the Constitution, adopted the Bill of Rights, adopted all of the subsequent amendments, and that should be the basis of constitutional interpretation by the courts and by the legislature and by the executive today. Now, what are we interpreting here? You know, we're interpreting the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So that's the text we're looking at. Now, the first question, I think, for an originalist is, you know, what's the prism through which you view that? You know, Mr. Gura talked about how the original understanding was that judges wouldn't defer to legislatures when they engage in judicial review, and I would disagree with that. You know, there's kind of a common view that Marbury creates judicial review. that they're, that's in some sense kind of created out of whole cloth in 1803 by Marshall, and that's not right. And so then that we're in agreement. But if you actually look at the case law before Marbury, in the period between the ratification of the Constitution and Marbury in 1803, there's actually a very substantial body of case law, federal and state, in which courts strike down statutes. So there's both judicial review and a particular approach to judicial review. In large part, it's deferential. Justice Iredell on the Supreme Court enunciates what's known as the clearly unconstitutional test. And that is the dominant approach. The exception is in structural areas. Courts strike down statutes that limit powers of juries, that limit or affect the power of courts. That's really what Marbury is about. And federal courts strike down state statutes that undercut the power of the national government. So judicial review is in general deferential, with the exception of these limited structural areas in which courts are really trying to protect political actors that can't protect themselves. Juries, courts, and the national government is being protected against state governments. Okay? So that's what judicial review is about. So when you apply judicial review and the original theory of judicial review to gun control legislation, to Second Amendment, it's an area of deference. This is the kind of statute that courts would uphold unless it was plainly unconstitutional. And a statute like the D.C. gun control statute is not plainly unconstitutional. So that's kind of the overall prism. Judicial review in this area, deferential. Okay, then now we move towards kind of the substance of it. Again, the text, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay. Now, how do we interpret that text? And I think really one of kind of the crucial threshold questions is, you've got a preface. A well-regulated militia being necessary to the security of a free state. That's the preface. Okay? And then you go into the right conferral. The right of the people to keep and bear arms shall not be infringed. Now, and this is a big dividing point in Heller. Justice Scalia, for the majority, says, well, the precedent, you have an English right, which he reads broadly. And the preface explains why, of all of the English rights that are out there, why this particular one is being protected. But the preface doesn't limit the right. So really, when you're interpreting the right itself, you don't focus on the militia part of the clause. Whereas the dissenters say the preface is important. You read it all together. Now, one thing actually, again, you're the expert in this. One thing that actually strikes me is when I was reading in preparation for this, the literature, a number of points say that this is the only preface in the Constitution or the Bill of Rights. And it's not. So, for example, one thing that I've written on is the Intellectual Property Clause, which also has a preface. And it is to promote the progress of science and the useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Okay, so that if you look at this as the analog to the Second Amendment, the right is Congress can create limited rights for limited periods of time, and the preface is the part that says to promote the progress of science and the useful arts. Okay. And usually when we interpret this, and I think correctly, we give weight to the preface. So Congress can't, for example, there's case law which I would say is consistent with the original understanding. A recent case in which the phone book, could Congress create a copyright protection in the phone book? It's a writing, but there's no creativity. And Congress has said, and the court has said, you can't do that, partly because we give weight to the preface. And I think that's appropriate here.